Hi everyone, I am Dr. D. Rajshekhar. I am at Business School, I am at University, and we are going to have a discussion on subject called Business Law, Unit 4, Companies Act 2013. So in this Companies Act, for today's session, we are going to cover all these aspects, whereas major principles, nature and types of companies, formation of company, memorandum and articles of association, prospectus, powers and duties of directors, winding up, corporate governance. So Companies Act 1956 previously, but later they made various changes in the Companies Act 2013. There is a vast difference between these two. The reason is the 1956, where they found there are certain gaps which are required to be fulfilled by enacting a new act called Companies Act 2013. So in this Companies Act 2013, there are certain important facts which they have introduced. One is 33 new definitions they have included, 470 sections for this Companies Act, which consists of 470 sections, 29 chapters and 7 schedules, and these are major important facts in the Companies Act 2013. In this Companies Act 2013, the administration, which comes under Ministry of Corporate Affairs, MCA, central government, there are 7 regional directors: the Kolkata, Chennai, Shillong, Ahmedabad, Hyderabad, New Delhi and Mumbai. Register of companies 22, but in Tamil Nadu 2, one is Chennai, another one is Coimbatore. The incorporation of company, the basic concepts of incorporating the company, that we have to see that availability of name, whether the name is available or not. Point number 2, filing the other documents. Point number 3, certificate of incorporation. These 3 are major parts. But what is meant by company? Company, as per section 2, subsection 20, com means with or together. Pan is called as bread, where association of person, group of people who took their meals together. Same way here, company is a corporate body and legal person. Group of people are incorporating with legal personality. This Companies Act incorporation, which is required as per various classification of companies on the basis of incorporation. It called as Special Act of Parliament. There is a company, and LIC, Public Corporation, or company legislation, Tata Iron and Steel Company Limited, Reliance Industries Limited and all, which comes under the companies legislation, which comes under LIC, Special Act of Parliament. And registered companies, chartered companies, the East India Company is an example, and registered companies means all the companies which are required to be registered. Statutory companies means the Act of Parliament or the legislation which is required. Say for example, State Bank of India Act is required, RBI Act is required. All these are all called as statutory companies. So company definition. There is an author called Justice Marshall. He defined company as an artificial being, invisible, intangible, and existing only in the contemplation of law. Another definition which was given by Chief Justice Haney, incorporated association. If you take any companies, the company which is required to be incorporated, point number 2, should be created by law. Then having separate legal entity, business is totally separated from owners. Perpetual succession, many members may come and go, but the company will be there for ever and ever. Common sale, it is called as official signature of the company. So there are various entities under this act. So access to capital means there are two, one is listed, another one is unlisted. Under members, OPC called one person company, private company, public company. Under control, on the basis of control, holding company, subsidiary company, associate company. On the basis of liability, there are two. One is limited liability, another one is unlimited liability. So company limited by shares, company limited by guarantee comes under limited liability, and another one is unlimited liability. On the basis of size, called small companies. On the basis of size. Then activity is called as dormant company. Inactive company is called as dormant company. Then the next one is other companies, other nidhi company, foreign company, producer company, government company. All these are all the other classification of companies. As I told previously, we have discussed on the basis of incorporation, which I have given some few examples of the companies also, what we have discussed in the previous slide. So on the basis of incorporation, statutory companies, okay, so special statute of the legislature or parliament is called as statutory companies, RBI, LIC, UTI, SBI. But these types of statutory companies, whereas the companies are enacted with the special statute, okay, for these type of companies, statutory companies, no memorandum of articles of association which is required. And the next one is registered companies, defined under section 2 of the Act. Then on the basis of liability, company limited by shares, company limited by guarantee, unlimited companies. So what is the difference between company limited by shares and company limited by guarantee? Unpaid value on the shares called as company limited by shares. Say for example, X party, X is a person who subscribed rupees 10, he paid rupees 6 rupees, not yet paid 4 rupees. Then the company may have right to call the person to make the payment of 4, not more than that. It is called as company limited. Company is having limited by shares. Company limited by guarantee. Same way here, person who has given the guarantee, company may have right to ask him, but what the amount which was agreed by him, but not more than that. It is called as company limited by guarantee. Another major difference between these two, company limited by shares can be happened during the process of the company. Company limited by guarantee can be happened during the winding of the company. So these are the two major differences. The next category is unlimited company. So unlimited companies, a company without limited liability is called as unlimited company, whereas every member is liable for the debts of the firm as per section 2, subsection 92 of Companies Act 2013, section 2, section 21 of company limited by guarantee which defines, and company limited by shares which comes under section 2, subsection 22. So these are major 3 sections which are coming under on the basis of liability. And the another important thing is on the basis of members, private company, section 2 subsection 68, the private company, minimum 2 members, maximum 200, minimum 2 directors, but the restriction on invitation to subscribe the shares is strictly prohibited, whereas transferability of shares also strictly prohibited. Even for quorum while conducting the meeting, minimum 2 members is required to be present in the meeting is called as quorum. Managerial remunerations not be applicable, but retirement of directors by rotation also not applicable. Okay, so these are the major points which comes under for private company. Public company section 2 subsection 71. Previously we have discussed minimum 2 members and maximum 200 members, but here minimum 7 members, maximum unlimited. Maximum unlimited for public company. Minimum 3 directors in the case of public company, minimum 2 directors in the case of private company. Restriction on invitation to subscribe the shares, there is no restriction, whereas they can give the invitation in subscribing the shares. And another important thing, transferability is totally restricted, but here the shares can be freely transferred from one person to another person. Quorum, minimum 2 members is required to be present, but here totally 5 to 30, or 5 to 30, but depend on the number of members. Managerial remuneration, yes, there is a ceiling limit which is applicable in the public company. and retirement of directors by rotation 2/3, whereas directors can be retired on the basis of rotation, the same principle which will be applicable in the public company but not in the private company. So these are the points which we have discussed on the basis of members for private company and public company. Now the another most important company is called as OPC. See, OPC is called as one person company. Section 2 subsection 62 says that only one person acting as a member, okay, then one person company is just equivalent to a kind of private company. So natural person, any person may have right to start the one person company, but previously they told that the residential status of the person 182 days, but as per new amendment 120 days, which is enough. So any person may have right to start this one person company, but one person may have right to start only one company. And another important, previously this one person company can be converted into either private or public. They have imposed various lot of important advantages for the purpose of conversion, either on paid up capital or turnover like that. But now as per the new amendment, whereas they have enacted, okay, so for as per this new amendment, the one person company may be converted into private company or public company without following any other limitations. There is no such limitations. Earlier it was there, but as per new amendment there is no such limitation. OPC one person company can be converted into either private or public, and the residential status 182 days, now 120 days. Even NRI also may have right to what? Start this one person company as per the new amendment. Then the written consent of nominee is necessary. If the person, since only one member, if he decided to appoint a nominee, written consent is required from that person, one who come forward to show his willingness to act as a nominee. So nominee consent also, which is required to be filed with the Register of Companies. Even while withdrawing his consent also, same thing, they have to give the notice to the member. Who the nominee, when he decided to withdraw his consent also, he should give the notice to the member 15 days. And also they can go for fresh nomination. Okay. So these are the points which we have discussed for one person company. So on the basis of members, one person company, private company, public company. On the basis of ownership. So on the basis of ownership, government company. See, government company which is not less than 51% of the paid up capital, either held by central government, state government, partly by state government, partly by one or more state government or central government, is called as government. Say for example, XYZ Limited is a company, whereas state of Andhra, state of Telangana, then government of India, then state of Karnataka. So government of India 30%, then state of Telangana 10%, state of Andhra Pradesh 10%. So as I told again, government of India. So 30%, other three states, Karnataka, then Andhra Pradesh, Telangana, totally 10% for Telangana, 10% for Andhra Pradesh, 20%, government, the Karnataka 20%, 40%, and for government of India 30%. So overall 70%, but we required 51%. So when these states where they have started to invest in any of the public limited companies, if the percentage exceed more than 51%, then we shall consider as these companies are comes under government companies. So if it is exceed, okay, not less than 51%, means should exceed more than 51%. Non-government companies, all the companies except the government companies is called as non-government companies. On the basis of control, means holding company and subsidiary company. Section 2 subsection 46 says that the holding company, a company is known as the holding company of another company. It means having control over the company. There are two important points, whereas this H company may have control over the other company. One is the percentage, okay, whereas nominal value of the nominal value. half of the nominal value share capital, but with the latest amendment, nominal value of voting rights. Voting rights is required. Half of the voting rights is required. Then only the company can be called as holding company. So previously the company holds more than the nominal value, but now more than the voting rights. At least 50% of the voting rights should exceed. Then only the company can be called as holding company. Or else H company who having 50% of voting rights, and the next point is the H company, the same H company is appointed more number of directors in the S company. S company is called as subsidiary company. So in these two cases, which company is having control more means H company, whereas voting rights also increased, and the next one is even the number of directors appointed by the H company also increased. So H company is having the control. So subsidiary company which comes under section 2 subsection 87. Holding company which comes under section 2 subsection 46. And another company is called as on the basis of other types of companies. Foreign company. Foreign company means any company incorporated outside India and doing place of business in India is called as foreign companies. Associate not for profit. Next one is associate not for profit. The very important section, associate not for profit, section 8. See, these associate not for profit registered as limited companies. Say for example education, charity. Central government may permit such registration but without addition of words what limited or private limited under this section. But memorandum and articles of association can be altered for other companies by passing special resolution, point number 1, and point number 2. Then they have to submit the documents by altering the memorandum of association and altering articles of association. Point number 3, while submitting the document, they have to submit the document to Register of Companies. Register of Companies will cancel the former registration, will issue the new registration. So these are the process which will be applicable for the companies where they decide to convert from one company to another company. They may have right to alter both memorandum of association and articles of association. They can do alter, but only one company, that the company doesn't have any right to do such alteration without getting any prior approval. So if they want to go for altered, they cannot be altered without approval of central government. Section 8 company alone. Central government even may have right to pass the orders of winding up of the companies, these companies. And central government sometimes what they will do, whereas any companies where they are not able to promote themselves, the central government will give the directions, orders for either amalgamation with any other company. So section 8 company, associate not for profit alone, who is having the major role means only the central government is having the major role. And another one is small company. Small company. Small company section 2 subsection 85. It just other than a public company is called as small company. But even the small company also with the recent amendment, paid up capital, previously 50 lakhs, then 2 crores, but now paid up capital 20 crores. As per new amendment 20 crores. The turnover previously 20 crores, but now there is amendment 40 crores. Okay, as per new amendment they have made some changes in what type of company means small company, paid up capital and turnover also. They have included some amount of changes with the recent amendment. It says that 20 crores of paid up capital, turnover is 40 crores. Previously 20 crores, now it is increased, and paid up capital also previously 50, now it has been increased. But these small companies will not include holding a subsidiary company, section 8 company, or company or body corporate governed by special acts. The next important classification is dormant company. Next one is dormant company, section 455 of Companies Act. So what is meant by dormant company? As I told already, it is an inactive company. Inactive company, but for future project future project or hold an asset or intellectual property. But for these dormant companies, there is no significant transactions which is required for 2 years. No significant accounting transaction is required, but they can make an application to register of companies for obtaining the status of what? Dormant company. Now you may have doubt. But the significant accounting transaction, other than this, they have to do certain things in retaining the dormant status. Point number 1, payment of fees by the company to register of companies to retain the status, and payment made by him to fulfill as per the requirement of the Act. Then the maintenance of office records also, which is very much important. Another classification called as associate company. Associate company, previously 20% they are given paid up capital, but now given here 20% of voting rights. One company were having influence in other company. Associate, significant influence. Associate company. Maximum these associate companies maybe joint venture process it will be applicable, but the percentage of voting rights which is required 20% or more. Other classification of companies are there, producer companies and nidhi companies. Okay, all these are all which comes under the various classification of companies. So far what we have discussed on the basis of incorporation, a statutory company, a registered company, chartered company. On the basis of members, private company, public company, one-person company. On the basis of control, holding company, subsidiary company, associate company. Okay. Now on the basis of size, then again the other companies we have discussed. Okay. So on the basis of liability also we have discussed. Company limited by shares, company limited by guarantee and unlimited company. So likewise there are various classifications, but in all these classifications it is easy for you to track the status of the companies in practical with the website called mca.gov.in, in short form Ministry of Corporate Affairs. Okay. So those who want to learn a lot about whereas the company is existing or companies, how much amount of authorized capital they are having, are they paying the tax, whether the company is still holding the status or not holding the status. Since we are discussing about dormant company, whether it is active or inactive, so all these type of queries which is easy for you to track the status with the help of Ministry of Corporate Affairs website called mca.gov.in. The next one is prospectus. Section 2, subsection 17, Companies Act 2013. A prospectus means it's a document. Okay, it's a document. It may be issued in way of prospectus, which includes notice or circular, advertisement or other documents, but inviting the public to come forward to subscribe the shares. Inviting the public to come forward to subscribe the shares of the company or the debentures of the company. But in this prospectus, abridged prospectus, shelf prospectus, red herring prospectus, deemed prospectus, there are various types of prospectus. But at the same time, in this prospectus, the contents which are presented. First one is name and register of the company, the content which is required. And another one is name and address of the company secretaries, then the auditors, the bankers, underwriters, important. Then dates of the opening and closing of the issue. If you take any prospectus, date of the issue and the closing of the issue which will be presented in the prospectus. Then declaration about the issue of allotment letters and refunds within the prescribed period of time. The allotment and the refund also within how many number of days whereas they are going to refund. All these type of details which are required to be presented in form of contents of prospectus. So the another section 26 which clearly explain about contents of prospectus, date and sign, name of the company, address of the register of companies, name of the company secretary, chartered accountant, chief financial officer, bankers, legal advisors, trustees, etc. Date of opening and closing of issue as I told already. declaration about the issue of allotment letter and refunds, statement from the board of directors on a separate bank account, details of resolution passed for approve the issue, and details of resolution passed, then later public offer for terms of present issue, details about the business of the company. So they have to provide all the details about the business of the company, underwriting, what about the minimum subscription and premium payable, issue of shares other than cash, and details of directors, how they are going to appoint the directors, and what about their remuneration. As I quoted already, for public company means then the managerial remuneration which will be applicable based on the ceiling limit, and details about the promoter's contribution. So all these points are which are required to be presented. Another important thing, in the incorporation, if a company wants to go for incorporation, memorandum and articles are duly signed by the subscribers to the memorandum. You know, private company minimum 2, maximum 200, public minimum 7 and maximum unlimited. But while calculating the 200 in private company, present employees or the employees, those who are ex-employees, are not to be taken into account while calculating the 200. And also while incorporating the company, the declaration by the aggregate, a chartered accountant, cost and work accountant, company secretary, and by a person named in articles as a director, manager or secretary, affidavit also, which is required to be present, then that they have to collect from each of the subscribers to the memorandum, and the person named as called as first directors to the effect, address for the correspondence till the register office is going to be formed, name and residential address, name and residential address of every subscriber to memorandum along with proof and identity, and the details of first directors named in its articles. Based on all these documents, so once the person who submitted all these documents, at last, whereas register of company is having right to issue a certificate called certificate of incorporation. Along with that, they will issue a CIN number, is called as corporate identity number. It is very easy to identify the company, to know one company to differentiate from the other company. So for that purpose, they will issue another number, is called as CIN number. Even for directors, any person, those who are going to act as a director, they should hold one number called DIN number, DIN, called Directors Identification Number. Then formation of company. See, a company comes into existence when a group of people come together to form an association. But what are the various stages are there in forming the company? Company means what? Group of people are joined together. They have decided to start a company, either various classification, what we have discussed, major, private, public or OPC. But what are the various stages? Point 1, promotion stages. Promoters are involved. Who are called as promoters? The person who is giving the idea to start the company. Okay, promotion stage. Second one, selection of name. Memorandum of association. Name clause, object clause, situation clause, liability clause, capital clause, subscription clause. But we need to know the name clause. Okay. So what about the procedure in order to know about availability of name? If same name which is existence, then the ROC is having, register of companies is having right to what? Reject the name company. Okay, for registration. So for that purpose, availability of name which is required for selection of name. Third one is incorporation, registration stage. As I told, for incorporation, okay, documents, memorandum, articles of association, the first directors, then the members as well as the subscribers, okay, and overall chartered accountant, company secretaries, advocate and affidavit, all the details which is required to be present to be submitted to ROC, incorporation. Then the raising the share capital. How they are going to raise the share capital? In what way they are going to raise the share capital? Either they are going to borrow from the banks or through the issuing the shares to the public or private company, private placement, selected group of people. In what way they are going to issue the share, raising the share capital? Okay. So there are 4 important formations: promotion stage, second one selection of name, third one incorporation, and fourth one is raising the share capital stage. So formation of company we have discussed, And next we need to know about another important concept that we need to know about important concept. So far we have discussed about the various classification of companies, company, incorporation, memorandum, article. Memorandum of association, there are various classes. Articles of association to know about internal regulations of the company. Internal regulations, share allotment, share premium, how you have allocated the shares, and to whom were all the directors, all these details which are required to be presented in the articles of association. Memorandum of association which depend on what clause. So what is the major difference between these two? Memorandum is a primary document, articles of association is a secondary document. Memorandum is a mother document of the company, then only articles of association. So that's why while going for alteration, that we have any person may have right to do the alteration on if they desire to convert from one company to another company. But as I told already, except one company, that they can go for altering what? Memorandum and articles of association by passing what resolution? Special resolution. Third one is what? Then they have to submit the documents to the ROC. ROC will cancel the formal registration. He will issue the new registration. Okay. So the next one is promotion stage includes what? So a person who decided to go on with the promotion stage, he should know about to discovery of various business opportunities. What are all the various business opportunities? Okay, as I told, promoter is a person who need to give an idea to start the business. So they have to involve in what? Identifying the business opportunities. Second one is detailed investigation which is required in collecting the information to what? To start. Assembling necessary requirements, at last the financial position also which is required to be known to him to what? In order to give the idea to the others to start the company promotion stage. Second one, selection of company name, either private company or public company, depend on the number of members. Okay, but while selection of name, both the company's names should not be existence, should not be same. Okay. Third one is incorporation stage. Incorporation stage, what? A company is to be incorporated by fulfilling the formalities of certificate of incorporation. But for that, MOA is one of the document, articles of another document, articles of association, and written consent of all the directors also is required. Okay. So once he has submitted, okay, a public to commence business, immediately what they will do? They will give the certificate of incorporation. It shows that the person may have right to what? Commence the business. So another point also I have told, when the ROC is going to issue the certificate of incorporation, CIN number also which is required to be presented, called corporate identity number. So memorandum section 2 subsection 56 can be altered from time to time. Okay, but this memorandum which clearly explains about the constitution, scope and powers of the company. Okay, the contents as per section 4, name clause, then the register clause, object clause, liability clause, capital clause, then subscription clause. Articles of association section 2 subsection 5. Articles of association. So these articles of association which clearly explains the rules, regulations and bylaws. Internal management of the company. If you ask what are all the internal management of the company, share capital and variation of rights, lien of company on shares, calls on shares, share certificate, transfer of shares, transmission of shares, then forfeiture of shares, conversion of shares into stock, share warrant, alteration of share capital, general meetings, whereas board meeting, annual general meeting, class meeting, all these meetings are called as extraordinary general. Board meeting is different, but general meeting means extraordinary general meeting, annual general meeting and class meetings. So these meetings which comes under the general meeting, board meeting which totally differ, which is used to be conducted by the board of directors, and the proceedings at general meeting. There is a slight difference, the general meeting to be conducted, okay, and the extraordinary general meeting to be conducted, board meeting to be conducted. There are various differences. There are various board annual general meeting at any cost not to be conducted on national holidays, and not only that within the prescribed hours, but once they have started, then they can go on conducting the meeting continuously. Board meeting, there is no any limitations, they can conduct as the extraordinary general meeting whenever they want to take the decision, then they can conduct the extraordinary general meeting also. But annual general meeting, which is most important, meeting to be conducted by the companies, but there are various rules in order to conduct the annual general meeting. The clear explanation about the annual general meeting, board meeting and external general meeting, class meeting, which we need to discuss. There is another subject called Companies Act 2013. Since we are discussing about the business law, Companies Act, only the brief introduction about the Companies Law, Companies Act 2013 alone, which we are going to discuss in the today's class. Then the proceedings of the board, then the manager or secretary, the seal, common seal, how they are going to issue the dividend and what process where they are maintaining for the reserve, accounts, capitalization of profit, winding up, and last one is indemnity. So all these are all called as the contents of the articles of association. Prospectus. Section 2, subsection 70. As I told already, the prospectus deals with, there are 4 major types of prospectus. But even public company also may issue securities as per section 23 to public through prospectus. Okay, it is called as public offer, and through even private placement, selected number of people, through a rights issue or bonus issue in case of what? Only listed companies. Private company may issue securities to whom means right issue or bonus issue through private placement. The major difference is here. Private company means right issue, bonus issue, private placement, selected group of people. But for public company may issue securities. But one more added point. What? Through a prospectus. Through a prospectus means what? Public offer. Public offer. They can able to generate the fund by issuing the shares to the public. It is called as what? Public offer. So these two are very much important between a private company and public company. But the prospectus, it is a document in writing. Okay, it's just a oral invitation. So oral invitation to public, whereas they have to come forward to subscribe the shares of the company. Then the next one is director. See, every individual person is called as director. Director appointed by whom? Board of directors. Okay, board of the directors of the company. Okay, so board of directors, collective body of directors of the company is called as board of directors or board. So there is a difference. Director appointed by board of company, section 2, subsection 34, called as director. Individual person is called as director. Collectively, body of directors of the company, group of people of the company, as per section 2, subsection 10, is called as board of directors or board. So what are the various powers of directors? There are general power and specific powers. There are 2 different powers, general power and specific powers of the directors. General powers means the directors may have right to inspect the books of accounts of the company. Also they may have right to what? Issue notices of the company meetings. They may have right to receive a remuneration, attend the meetings of the company of board of directors. So what is meant by specific powers? See, specific powers means issue debentures. Specific powers means issue debentures, invest the funds of the company, make loan on behalf of the company. Make loan on behalf of. So first we need to identify the director, means the individual person can act as a director. A collectively group of people appointed by the board is called as board of directors. But these directors, there are various types of directors. Resident director, woman director, additional director, alternate director, nominee director, small shareholder director. And another most important director is independent director, executive directors and non-executive directors. Like this, there are various types of directors are there. Casual vacancy directors, like that various types of directors are there, but independent director role is very much important. As I told already, the complete types of directors which we are going to discuss a subject called Companies Act 2013 along with the sections and examples which is required to be present in a different way to understood the various classification of the directors. But as per this chapter 4 in the business law, what we are discussing now, so powers of directors, which clearly says there are 2 types. One is general power, another one is what? Specific power. What are the various duties of directors? So powers mean general and specific power. What are the various duties of directors? See, duties of directors means inspecting the prospectus. Since you have given the work to the promoters in issuing of the prospectus, just like that, a director cannot hold or withdraw his responsibility without knowing what which is happening while issuing the prospectus. He should know. He may have right to what? Inspect the prospectus. And the second one is signing the prospectus. Director's role, which is required to be sign the prospectus, presenting the annual statement, holding the statutory meetings and forwarding that statutory report also, governing the general meetings. The directors are continuously take part in the general meeting. They may have right to declare or paying the dividend, present the annual accounts and sending copies. At last, on and off what? They have to send the copy to the ROC. ROC is nothing but register of companies. Liabilities of directors. Powers we have discussed, duties we have discussed, then liabilities. See, liabilities of this directors, Companies Act casts a criminal liability and a civil liability. So when this criminal liability and civil liability which will be imposed on the director. So officer who is in default, the concept is called as officer who is in default, which includes what? Executive director and KMP. KMP is called as key managerial person. So what is my definition for officer in default? Officer who is in default, purpose of any provisions in this act which enacts an officer of the company, commonly it's officer which is required, but who is in default liable to pay any penalty, as I told, which includes whom? Executive director. KMP is nothing but company secretary, manager, managing director, whole-time director, then chartered accountant, chief executive officer, chief financial officer. All these people are called as KMP, key managerial person. So then the who is in default shall be liable to pay any penalty or punishment by way of imprisonment, fine or otherwise. Means any of the following officers of the company. Any of the following officers, just I have told, the whole-time director as well as KMP. All these people are engaged. Okay, they have to do their services. In case if they fail to do these services, even in the prospectus also misstatement in prospectus, civil liability and criminal liability which may be imposed. Even here officer who is in default, executive director as well as key managerial personnel, again the liability may be imposed on directors. Then the next one is winding up of company. See, winding up of company, previously as per Companies Act 1956, section 433 to 483 they have given at the jurisdiction of High Court. Okay, members voluntarily they can winding up, even creditors. But now since we have enacted a Companies Act 2013, okay, compulsory section 271 to 303, compulsorily section 271 to 303, National Company Law Tribunal, okay, may have right to direct the company for winding up. Voluntary winding up is that section 304 to 365. Voluntary winding up. There are no separate creditors and members voluntarily winding up. There is only one winding up where both members and creditors' consent are required. Previously, members and creditors, they separately they have to get the consent. Now, as per Companies Act 2013, as I quoted section 304 to 365, it is totally changed. Okay, so where both members and creditors' consent are required, voluntarily the company can go for winding up. Okay, but winding up process which is not very easy as in the other forms of business organization. Even for partnership, even for LLP, it is very easy to go for winding up. But for Companies Act, it is not very easy to go for winding up. But there are two processes, as I told, section 271 to 303. Okay, National Company Law Tribunal. Okay, so if you the structure of the Companies Act, one is MCA, Ministry of Corporate Affairs. Second one, Regional Director. Third one, Register of Companies. Then last, NCLT, National Company Law Tribunal may have give any direction to the company. So specifically as per section 271 to 303, they may have right to give the direction for what? Winding up of company. Another one is voluntary winding up. And another NCLAT is there, called as National Company Law Appellate Tribunal. But since we are discussing about the winding up, but try to remember section 271 to 303, National Company Law Tribunal may have right to give the direction to go for winding up. In case if the company decide to go for voluntary winding up, then previously members, creditors, they need to present their consent in a different way, but now which is not yet required. Both at a time can collect members and creditors' consent. If at all, if it is satisfied, then directly they can go for what? Winding up of company. So who can file the petition for winding up of a company? So if a person decided to go for winding up of a company, but there is a question mark, who can file petition for winding up of a company? Point number 1, company or creditors, shareholders, any prospective creditors, component of prospective creditors, a registrar may have give the direction, liquidators, the person authorized on behalf of the state or central government. Okay, so again there are major 7 points. Okay, 7 major people are there can file petition for winding up of a company. Point number 1, company. Point number 2, creditors. Point number 3, shareholders. Then contingent or prospective creditors. Then registrar, liquidators, authorized person on behalf of state or central government. So where to close here? Company under Companies Act 2013. Winding up or strike off. See, winding up is a proceeding under which companies to be gets dissolved by, as I told, NCLT, National Company Law Tribunal. For that purpose, what they will do? They will appoint a liquidator. They will appoint a liquidator for winding up process. Another one is strike off the name of the company. Okay, on NCA portal, whereas they can strike the name of the company. The last point which we are going to discuss, as I reported here, corporate governance. So what is meant by corporate governance? Corporate governance is to determine how power is distributed among shareholders, management, board of directors. So corporate governance means how the power is distributed among shareholders, management, board of directors. So corporate governance is made up of 2 words. One is corporate, another one is governance. One is corporate, another one is governance. The word corporate is used for relating to business. Is used for relating to business, but especially for what business means? Large business. Okay, large business. Whereas the corporate governance is very much important. And what is meant by governance? The corporate is for related to a business, especially large. What is meant by governance? Governance means decision making and implementing those decisions. That the company need to take decision and to implement those decision making. But for that there are 4 important points. TDAI, called as TDAI. TDAI called T for transparency, D for disclosure, A for accountability, I for integrity. All the statements to be transparent, whereas any stakeholders can able to see. Disclose, they have to disclose all the statement. Accountable, directors are accountable. Last one is integrity. So transparency of operation, accountability towards shareholders, fairness in dealings. All these points which are required to know about why this corporate governance is very much important. So if you ask me why the corporate governance, as I told, transparency, accountability, control, trusteeship, last one is ethics. Okay, corporate means whereas large business, relating to business, especially large business. Governance means decision making, implementing those decisions. Okay, but these 2 to be fulfilled with the help of TDAI. T for transparency, D for disclosure, A for accountability, I for integrity. So far for today's session we have discussed about definition of company, then what are the various classification of companies, what are the new amendments which are enacted under Companies Act, what is the present procedure with sections and definitions enacted under Companies Act 2013, difference between memorandum and articles of association, to alter what procedure, prospectus, contents of prospectus, articles of association contents, memorandum of association contents, and the last one is winding up, what is the procedure for winding up, and then we have discussed about powers of directors, liabilities of directors, duties of directors, at last corporate governance. So all these are the very much important contents. The people, those who are acting, are playing a major role while working in any of the companies. They should know about the Companies Act 2013, and above all, those who are professional people, those who are acting in holding good position, also they should know the meaning of corporate governance, especially the corporate governance which also includes ethics. Okay, so thank you all. We will see in the next session. Thank you.